Hello, everybody, and welcome to another Think Legal conversation. Today I'm chatting with Chante Mouton on the topic of international divorce. Today's topic follows on our webinar a few weeks back where we had some internet woes, and we'll be going through the main topics of conversation and the questions. Thank you for joining me, Chante.
Thank you so much for having me.
Excellent. Yeah, so the topic today, obviously, Chante, is going to be the top 10 questions that you've been asked in your practice as a family lawyer dealing with international divorce. And some of them are quite obvious, I think, and some of them are somewhat bizarre, aren't they? But in any event, be that as it may, these are the 10 questions that you've been asked the most in your divorce practice. And I think let's start with the obvious one. Can I get divorced in South Africa if I'm living overseas?
Okay, yes. So basically, it's a yes and no answer that I'm going to give you. So, what we need to look at in terms of if I give you the yes answer, we need to determine whether your spouse still resides in South Africa or whether you are possibly domiciled in South Africa. So, in order for us to do this, we actually need to look at Section 2(1) of the Divorce Act that deals specifically with domicile. So, what this section basically says is that the court will have jurisdiction to adjudicate over divorce proceedings if one of the parties or either both of the parties are one, either domiciled in the area of the jurisdiction of the court at the time that this divorce proceedings are instituted, or two, that either or both of the parties should be ordinarily resident within the jurisdiction of the court. So what this basically means is that if the court does have jurisdiction, meaning one, that you are either domiciled or ordinarily resident in the jurisdiction of the court, then yes, the court will have the authority, if I can put it that way, to actually divorce the parties, even if you are overseas at the moment. Now, the big thing we need to look at is the no answer that I mentioned previously. So if yourself and your spouse has actually departed out of South Africa completely and you have no intention of returning to South Africa, then the court will not have the jurisdiction to divorce the parties.
What domicile? How does one explain the concept of domicile to a client sitting in front of you wanting to know, am I or am I not domiciled in South Africa?
Yes, okay. So domicile is basically where you regard yourself to be permanently living. So if you were to ask yourself the question, where do I reside? Where do I live? And your answer is, well, I live in South Africa, I grew up here, then that would be regarded as your domicile. So we deal with different types of domicile, which I'm not going to go into too much at the moment. But what we need to look at specifically is we get domicile of origin and we get domicile of choice. So we're going to deal with two elements in this regard, right? And the first element is the lawful element. So we need to decide, are you lawfully residing in a specific place? So if you have a visa, for example, or a valid passport for that matter. And then the second element we're going to look at is what is your intention? If you intend to reside in a specific place on a permanent basis, that place will be regarded as your domicile. And that's how we determine it.
All right. So, and obviously this intention thing is quite a difficult thing to ascertain. I suppose you would have to look at the circumstances surrounding where you are. And for example, if I were to move to the United Kingdom, but I still have a house and two cars and a cat, etc., waiting for me in South Africa, it's going to be difficult to prove that I intend to settle there for an indefinite period. So under those circumstances, even though I would be in the United Kingdom, South Africa would still obviously be my domicile, and it wouldn't be a domicile of choice. It would remain a domicile of origin. So
Yes.
as I understand it, every person who's born wherever they are born and they are a citizen of that country, that is their domicile of origin. And you can then
Correct.
change it by means of this two-step process of being lawfully present and obviously having the intent to settle. What about undocumented immigrants? You know, we have a big problem in South Africa, for example, with people throughout the whole of Southern Africa flocking to South Africa for financial opportunities. Some obviously here lawfully, some not here lawfully. What would the position be with regards to those people? Would they be domiciled in South Africa?
No, so they cannot be domiciled in South Africa because if we look at the first element, which is that they lawfully need to reside in a specific country, since they don't comply with that factor, no, they will not be able to get divorced in South Africa.
All right, excellent. So once we move past the whole idea of domicile, either South African expats getting divorced from overseas or expats from other countries um, coming to South Africa and then wanting to get divorced in South Africa, this leads us to the third question, which is basically the following. I was married in terms of the laws of another country. Will a South African court be able to divorce me? And what is the state of affairs in terms of that?
Yes. So the answer is yes. A South African court will be able to divorce parties whether they were married in terms of the other laws of a country. I usually like to use England for some unknown reason as an example. So let's say the parties were married in England in terms of the England laws, but subsequently they come to South Africa and they reside here. Right? A South African court will have the necessary jurisdiction to actually divorce the parties, but there's a few things that we need to look at, and this is actually where we go back to domicile or ordinarily resident, right? So if the parties were living in England at the time of the divorce, however, they've moved to South Africa, so they are domiciled here, they have the intention of staying here, then yes, the court can actually divorce them. However, if they were ordinarily resident for a period of 12 months prior to instituting the divorce, then yes, the court will still have the necessary jurisdiction to divorce the parties. And if we take a further look at Section 7, Sub 9 of the Divorce Act, this act actually grants our courts the same jurisdiction or power as any other competent foreign court to make orders regarding the laws of England in that regard.
Oh, that's very, very interesting. So incidentally, just to confirm, from what you said, I think you meant to say if the parties were married in England and then moved
Yes.
to South Africa. Okay, great. So they're not getting divorced in England and then hightailing it
No.
to South Africa.
Yes.
That would be a bit strange if they did
Yes.
that together with a divorce. So um, that actually takes care of the fourth question as well, which is how will our assets and liabilities be divided? If you're married in terms of South African law, very simple, either community of property, ANC accrual, or ANC without the accrual. But if you were married in terms of a different law, our courts can actually almost step into the shoes of those courts and deal with it. But that's obviously something that's quite hellishly and fiendishly complex, you know, for a court to really understand the laws of a different country. So let's quickly go into some practical aspects. In terms of situations where one spouse is in South Africa and let's say the defendant is residing in, let's pick on the UK again. What is the state of affairs? Can you issue a summons against them? How do you get it served on them?
Yes, so you can issue a summons against a spouse even if they are living in England or overseas or whatever the case may be. And this is by way of something that we actually call an edictal citation application. So the Uniform Rules of Court, specifically of the High Court, deals with the process on how to approach it. But basically what we are doing is we are asking the court to grant us a court order giving us consent to actually serve the summons on the person whilst they are outside of South Africa.
Excellent. But what about cases where you don't know where the person is? And that takes us to our very next question. You know, my spouse is outside of the country. I have no idea where they are. The last thing I heard, they were on their way to Eastern Europe and they were in X country, but apart from that, I have absolutely no idea where they are.
Yes, so this is actually another application, and we usually bring it in conjunction with the edictal citation application. But this is called a substituted service application, right? So in the world we live in today, 99.9% of people in instances like this will have a form of social media. So whether they have WhatsApp or Instagram or Facebook or email at least. So what we then do is when we bring the edictal citation application, we explain to the court that we don't necessarily know exactly where this person is. We know he's, for example, in Scotland, but we don't quite know exactly where he is. But we know he's active on Facebook, and we know he uses his email because he's been corresponding with our client on email that way. Then we ask the court to grant us the indulgence to actually serve the summons on this person by way of email. I've actually had a case where I've served a summons on Facebook.
Sure.
So yes, yes.
All right. And even WhatsApp, I suppose one can
Even
use,
WhatsApp,
or
I've done that too. Yes.
I don't know how one would do it on Instagram if you have to do a selfie next to the summons,
Next to
but
the documents, yes.
fair enough. I suppose you can do it. Let's talk about kids. My spouse won't consent to me returning to my home outside of South Africa with my child. We've seen this a couple of times. Parties that had moved to, for example, United Arab Emirates or the UK or North America, come back for a holiday, and all of a sudden the pawpaw hits the fan, and the one spouse says, "Well, you are not taking the child out of the country." Section 18.3 says, "I am co-guardian. I must consent to their removal. I will not consent." What can you do in those instances?
We deal with the word consent, and I'm actually very glad that you did mention it because this is the determining factor. So if a spouse does not give the consent for the minor child to be removed out of South Africa, the party who is refusing, or apology, so if a party unreasonably refuses such consent, right, the parent wanting to take the child out of South Africa can actually approach the court and seek the necessary relief from the court to be able to remove the minor child from South Africa.
Excellent. And I suppose that would come down basically to the best interest of the child standard. You would have to show the court that it's in the child's best interests to be removed.
Yes, yes. So the court will look at a few things, being the best interest of the minor child will obviously play the biggest role, but the court will also take the wishes of the minor child into consideration. If the minor child, for example, has been living with mommy for the past 10 years, daddy did not really play a big factor in her life, and now mommy wants to move to the USA, I mean, obviously that child is going to want to go with her mom.
Um, I suppose there's a corollary as well. So one has the spouse who wants to remove and the other party refuses unreasonably. Then we have the spouse who's a flight risk, who we suspect will be departing from the Republic unlawfully with the children. What can a spouse that wants to prevent this do at the end of the day?
So if a spouse suspects that, for example, the mother is going to flee the country with the minor child, he can actually bring an interdict. So we can launch an urgent interdict in the High Court, requesting the court to actually interdict and restrain the mother from removing the child from court. And should she then remove the minor child, there are various ways that we can deal with it, which I'm sure is going to pop up shortly.
Absolutely. And I think this is going to be our last question before both of us have to head back to the salt mines, as it were. What if my spouse has already removed the kids? Section 18.3 says, but they can't. Well, but they did. What
Yes.
can I do in those instances?
Well, in those instances, we deal with the Hague Convention of the civil aspects of international child abduction, right? So we form part of the Hague Convention, and we basically have 101 signatory countries who forms part of this. So should it happen that the mother removes the child and she flees, we can get into contact with the Hague Convention and deal with them specifically in order to ensure the safe return of the minor child.
And when you talk about getting in contact with the Hague Convention, I'm assuming you mean the entities. created by the Hague Convention. And what would those entities be at the end of the day?
So we basically have central authorities, and in South Africa, the central authority is actually the offices of the family advocate. So we will get into contact with the offices of the family advocates and start the process from there on.
Excellent. Right, Chante, this is a question that you didn't prepare for. What is your best piece of advice for someone going through an international divorce off the top of your head and from your heart before I let you go?
Perfect. My best advice that I can give you, do not fight. Try and agree on the jurisdiction of the court, because in some instances, both South Africa and, let's use an example, Australia can have the authority to divorce the parties. So if the parties can agree and consent to a specific court, the divorce is going to run a lot smoother. Otherwise, you're going to sit with a case where a summons is instituted both in South Africa and in Australia, and that's just going to cost a lot of unnecessary money.
Double costs, double hassle, double lawyers, and no one likes double lawyers, I suppose. So
Definitely not.
on that note, thank you everybody for watching. Chante, thank you so much for your time. This
Thank
has
you.
been a Think Legal conversation on international divorce.
The information contained in this video is distributed free of charge for educational purposes. Whilst we have taken all reasonable steps to ensure that the information contained herein is correct and up to date, insofar as the law in South Africa is concerned, the law remains a nuanced and complex field of study, replete with many exceptions and conditions. Please, therefore, do not utilize this information as legal advice, which it is not. When in doubt, consult with a legal professional. For more information, please feel free to contact our offices.